I'm delighted to see you all here. I'm delighted we have such a great panel. And I'm delighted that the takings jurisprudence is so hot now. I've been doing this since 1985. I wrote my student note on the original understanding of the takings clause. And I've spent 20 years when my colleagues have had kind of great attention to their work in equal protection or due process or freedom of religion. So I'm glad that takings is now the sexy topic. And I think there are a couple of things that make it so important right now. One is the sharp outcry over one of the three cases that the Supreme Court decided this past term, Kelo versus New London. We'll be talking about that and the three other Supreme Court cases from this term. But I have to say, when the court upheld the action of New London, which in essence transferred private property from one individual to another, I was astonished by the outcry that it provoked, which you see in the newspapers, reporting legislative response. It's been an attack from conservatives, which is not surprising to me, since it was a 5-4 vote, with the conservatives being for and Justice Kennedy being the swing vote. But it's also been attacked by a lot of people on the left as well. Ralph Nader wrote a column, for example, attacking it as special interest. And it's extended even into popular culture. Since I've always done takings, takings is a big topic at my family dinner table, and my 8-year-old and 9-year-old are very familiar with it. But that really hasn't extended to the general populace. But Kelo seems to be changing that, and I don't know how many of you follow Tank McNamara, which is one of the long-standing comics. That's the story of a TV sportscaster, former athlete, and it's usually about athletics and sports. But the most recent series has been about Kelo, starting with the first one in the strip shows Boheck Street ball fields, free to all, have fun. Somebody's chasing after a ball and says, I got it, I got it. And then a surveyor says, this is where the marble stairs to the day spa will go. And the person who's playing outfield says, this can't be good. And then in the second one, then we have the kind of the case law exegesis. Back in the 1950s, says the catcher, a landowner who loved to play pickup ball, set aside 10 acres for ball fields and set up a trust to maintain it. Tank McNamara says, has the trust money run out? And the catcher says, no. The Supreme Court ruled that cities can condemn private property and give it to other private property owners if it's called economic development. And the Boheck Street ball field sign now has slapped over it, Yuppie Dominiums at Heather Heath Lane Phase 4, an eminent domain corporation development coming soon. And the takings clause is also playing some significance in the confirmation process of Judge Roberts, who, as we've often heard, does not have a long public paper trail. But his two notes in the Harvard Law Review were both on judicial oversight of economic regulation. One was on the contracts clause, and the other was his view of the takings clause, which, in retrospect, in a stunning note, he adopts a view of the takings clause that is actually slightly to the left of Frank Michelman's. And so one that's been pointed to by people like Jeff Rosen is suggesting that he's moderate, even as Judge Robert in his confirmation hearings 2 years ago distanced himself somewhat from his juvenilia. So those are two ways in which the takings clause has become very, very current right now. And as we saw in our three cases that we'll be talking about, two of them were decided by 5-4 votes. So it's one where the Supreme Court is very nearly in equipoise at a time of transition. To discuss where we are and where we're going, we have a panel that's really, I have to say, is really absolutely extraordinary. I was just, I could not believe when I was given the list of who would be participating to see who we had assembled. So starting all the way, ironically, on the left is, I guess that's right, is Professor Stephen Eagle of George Mason, who's a leading commentator on the Takings Clause, very thoughtful, very insightful, and I want to thank him for coming. And since I'm going to be in a similar position at the Federalist Society Convention in November, I particularly applaud your appearance here today. Next, we have Caitlin Halligan, who's the brilliant New York State Solicitor General, formerly a clerk for Justice Breyer. And then Joe Sachs, who's a professor emeritus at Berkeley, former counselor to the Secretary of Interior. And among his landmark contributions to scholarship is really the author of two of the most critical articles on the Takings Clause, which have really, both in the Yale Law Journal, have really shaped the debate about takings for the past, at this point, 40 years. So we're very fortunate to have him. Lois Schiffer, who is now in private practice, but was for 8 years Assistant Attorney General for the environment in the Clinton Justice Department, and I had the privilege to work with her when I was a deputy in the Office of Legal Counsel, and Lois is really one of the great champions of the environment and a real hero. And Seth Waxman, who is now a partner at Wilmer, teaches at Georgetown, and was Solicitor General in the Justice Department. Attorney General Janet Reno once referred to Seth as the poet laureate of the Supreme Court bar, and I think that's entirely fair. His eloquence and his insight are really unparalleled. So thank you very much all for joining us. The way in which we're going to work this, we're going to focus in on the three cases that the court looked at this term, which are, we're going to start with San Remo. We're then going to talk about, we're going to start with Kelo. We're then going to talk about Lingle and then San Remo, and then a more general discussion. Just in terms of kind of framing why these are so, these are really critical cases, I think. The Takings Clause, part of the problem of the Takings Clause is that there's no easy way to read it. Nor shall private property be taken for public use without just compensation. There are two easy ways to read it. One is that it just applies to physical seizures, nor shall private property be taken for public use without just compensation, which means that regulatory takings, that there's no regulatory takings doctrine, because it only applies to eminent domain and physical seizures. The other is the approach that Richard Epstein has passionately developed, which is property means value, nor shall private property be taken for public use without just compensation. Anything that diminishes the value of property is a taking. In terms of the case law, the originalist view that it just applies to physical seizures is at odds with 100 years of regulatory takings doctrine. And the Epstein view is at odds with 100 years of upholding legislation that has, more than 100 years, that has redistributive consequences, and including things like progressive taxation, minimum wage laws, maximum hours laws. So there's got to be some middle way, or else we have to reject the case law. And there are a number of big issues. One, as we tried to mediate that tension, one is the relationship between the Takings Clause and the Due Process Clause. As a historian, I think there are two. Takings and due process are originally totally distinct. Takings is eminent domain. Due process is, substantive due process is when something's within the police power. When it's harmful, the state can stop it, and it doesn't have to pay compensation. It can shut down nuisances. And so they're two entirely discrete doctrines. What happens about 100 years ago are two things occurred roughly at the same time. One is that muddle the kind of the clear lines between takings and due process. One is that the Takings Clause is incorporated against the states through the Due Process Clause. And then the other is there's a category of government regulation that doesn't fit into either box, where the state is regulating things that are not so harmful that it can shut it down. And it starts really in things like rate regulation, utility regulation. How do you treat that? Because the classic due process regulation would say, rate regulation, the state could set rates at a level in which you lose money. But that doesn't work. Or does the state have to compensate the property owner? That doesn't work either, because then you don't have rate regulation. So that's really, due process and takings are really kind of mixed in the court's jurisprudence. And since that time, it's really been muddled. So for example, like Mann, Pennsylvania Coal versus Mann, which is the classic takings case, there's a big argument about whether it's a takings case or a due process case. And the reason why that has consequence and a real cash out is, to the extent that due process doctrines are alive in takings, kind of older notions of substantive due process, which involve heavy oversight of government activity, are smuggled in to takings jurisprudence at a time in which economic substantive due process involves a very low level of scrutiny. So that's really what Lingle is about. Another big issue is public use, which there are kind of two doctrines in the case law. Is public use or public benefit? Does it mean that the government is actually using the property, or does it mean that the property is being taken in a way that benefits the public? And that's what Kelo is about. And then an issue that is of fundamental importance, though, for somebody who's not strong in civil procedure, like myself, almost incomprehensible, is when you get to be in federal court on takings matters, which is what San Remo's about. So let's start with Lois talking about Kelo.
Okay. This is the very fast once-over, and I'm going to give one point that is outside of Kelo, but I think is a worthwhile context, and that is, in fact, the three takings cases of this term follow on some takings cases of the past several terms, including Lake Tahoe, which was a very significant regulatory takings case of a few years ago, where the Supreme Court really cleared away a lot of debris and a lot of doctrines and said, well, we're really going to stick to a fairly strict test for whether something is a regulatory taking, and they reinstated clearly something called the Penn Central case, for those of you in the know, but a set of very specific factors that have to be looked at in order to determine whether government regulation steps over the line into taking that requires compensation. And I think, and indeed, the Federal Circuit, which has primary responsibility for interpreting takings law, has adhered pretty strictly to Lake Tahoe after Lake Tahoe, with an exception we'll mention in a few minutes. And so these cases came up in a context where takings law was really moving back toward what I would say was a more a stance in the regulatory takings area, at least, where the courts were really going to give more latitude to the government. Kelo, you can't miss. Here it is on the front page of your New York Times today, just in case you thought that it was not an important case. And so, although the reports on this case have been, I would say, somewhat exaggerated, the key facts by now must be known to almost everybody, and that is the city of New London was in significant economic decline, like a lot of inner cities. In 1996, a military facility pulled out, leading to further decline. The state was concerned and got together with the local government, and however it came up, Pfizer said that it would build a facility near one of the most problematic areas, the Fort Tuthill area, and in return the state and local government said, and we'll try to use that as a magnet to really create redevelopment in this area. They involved the local redevelopment authority, which had extensive planning, both that there was a comprehensive plan and there were significant process factors, which are significant matter for the court later. And they developed a plan for redevelopment that had a number of parcels and a number of different approaches, which included housing, a river walk, a park, other what we would call nice urban amenities. And and they needed to acquire land to do it. There were about 100 parcels that were needed for what is, I think, a 90-acre development, and most of it was acquired by willing buyers and willing sellers. But there came to be about 15 parcels of land where there were not willing buyers and willing sellers, some of which were properties held for investment, not little old ladies, in fact lost on the press. But there were two people who got particular attention. One was Suzanne Kelo, who it turned out had bought her house in 1997. She was not a long-standing person there, but she liked her water view. And the second was another person whose family had actually lived there since the 19-teens, the 1920s, and she has a very sympathetic story to tell, although the radio interviews I've heard suggest she agreed that the neighborhood was falling down around her. So the government of New London, after they waited and tried to, the Redevelopment Authority, after it tried to acquire this property, couldn't, and so it sought to use eminent domain authority to acquire the property. Kelo and the other holdouts sued to say that there was not a public use here within the meaning of the Fifth Amendment that you've just heard, and so the government couldn't go forward. There was a lot of action in the courts below. Excuse me, in the interest of time, I won't go through it. The case got to the Supreme Court, which took there had been a 4-3 decision in the Connecticut Supreme Court finding in favor of the Redevelopment Authority. The Supreme Court took cert. I think a lot of us who follow takings law were quite concerned that this might be the opportunity for a real change in the law. By a 5-4 decision, the U.S. Supreme Court, in a decision by Justice Stevens that is quite consistent with what the law has been for many years, essentially affirmed that the actions here were within the meaning of public use in the Fifth Amendment. Now, what did Justice Stevens wrote the majority decision for 5 people. A lot of attention is given to Justice Kennedy and his concurrence, which is indeed a concurrence, but Justice Kennedy also joined the majority decision. So the majority decision itself is on behalf of 5 people. What did the court say? Well, the first thing Justice Stevens said is that, could I get some water? Is that we're going to look at the long line of cases that have been decided since approximately 1906, which have held that public use what public use means and doesn't mean. So the first thing it doesn't mean, what won't fall within this that the government can take, is property taken for A and given to B for the benefit of B. That's clear. So that's all these fears of we will take it from a little hotel and let somebody build a big hotel for their own benefit, nothing else, clearly off the map. On the other hand, what has always clearly been protected is if the property is taken for a project which is for use by the public, even if the project that is for use by the public is built by a private person. An example of that is taking a property to use by a railroad when the railroad is then going to be a common carrier. All right, so those are 2 poles which says Justice Stevens, everyone agrees how they come out. This case is in the middle. And it's in the middle because it's not used for the public, but it is for what it has been characterized as a public use. That is, it serves to benefit the public. And Justice Stevens then goes through a very long line of cases, which are, in the way of public lands cases, always very interesting. He talks about agriculture and mining in the 1900s, with a very interesting discussion of Nevada saying if we couldn't have taking so that we could create mining operations, the state of Nevada would basically fall apart. But then he also goes through in some detail, starting in the 1950s, the cases that are the most similar to the case at hand, and that is a case called Berman, which actually arises out of Southwest redevelopment in the District of Columbia, where there was a decision that it was a very problematic area of the city. There are a lot of statistics given in the case about how many outdoor toilets there are and that there's no plumbing and the very sorry state of affairs. The area was plainly 97% minority housing. And the court unanimously, in a quite eloquent decision by Justice Douglas, said that's a public use because the purpose is to take this property, looking at all of the parcels, not just one parcel, because Berman was the successor to a person who had a store that was not itself blighted. And looking at that for community purposes, we find that that's a public use. And so Justice Stevens goes through that, and then he goes through the follow-on cases, including a case called Mitkiff, which had been authored by Justice O'Connor, which related to Hawaii basically saying to the few landowners that there were, we're going to take your property and sell it to other people to diversify the ownership base. And so what Justice Stevens said is basically what's going on here is completely consistent with 100 years of case law in finding that there is a public use. And so I find that there's a public use. He did not invoke, but others in their discussion did invoke, the police power argument that if anything that's rationally related to a conceivable public purpose actually will meet the public use test. I would say it informs the background of the test. But basically, Justice Stevens said, all we're doing is reaffirming a long history of cases. And, said Justice Stevens, not in these words, but we're adding some extra cautions. Because what I find here is that there was a comprehensive plan and there was extensive process. There'd been extensive fact-finding by the local land use commission before they went, and discussions with the public before they went forward. And in the absence of those two factors, it isn't as clear how the case would come out. So that's the standard. It really is reaffirming, with possibly these extra restrictions, a very long history of cases. It is not, contrary to what the New York Times front page says, an upset the apple cart decision. It would have been upset the apple cart the other way. Now, what does Justice Kennedy say? Justice Kennedy basically joins the majority, but goes on to say, I find there were really a number of factors here that influenced my decision. Not only was there a comprehensive plan, but there was also a serious economic problem in this area. It was a citywide depression. There were projected economic benefits which were not de minimis. They were serious projected economic benefits, and there was substantial procedures. So you can say, well, Justice Kennedy really added a few extra components, or at least that's what made him comfortable. Then, in addition, Justice Kennedy has a quite almost funny discussion where he talks about, and in any event, we really have to keep how I read it, the words he used are we have to have meaningful rational basis. What is meaningful rational basis is different from rational basis. We don't exactly know. But if you look at what the discussion is about, what he really is saying is, if it looks fishy that this is being taken for really to benefit a private use instead of to benefit more broadly the public, we need to keep our antenna up, and we really need to then examine the facts. And I think it is not more than if it looks fishy, we ought to sort of follow our nose on it. The porridge isn't just okay because it seems to be okay. If there's something funny about it, we ought to take a harder look. The dissents, because I'm run over my time, I'll say very fast, or Justice O'Connor has what has been now heavily reported in the newspapers, a famous dissent. What is most interesting about her dissent, where she basically says, private property is private property, and if what happened here, that if it's being taken just for an economic use, that really, as far as she is concerned, is too much of an invasion of a property interest, and therefore doesn't meet the public use test. But what is interesting is she goes through the same 100 years of cases that Justice Stevens goes through and somehow reads them completely differently. And how she distinguishes her own cases is to say, well, there was really serious harm, and we're not sure that here we're remedying such serious harm. That isn't what those cases said. Those cases really used the very broad police power test, and it's not really a fair reading of the history, but that's her view. She writes for 4. Justice Thomas then dissents separately in a decision that basically says, I want to go back to the original intent of this. And then in what I can only call a sleight of hand, he suddenly says, well, we really need to look at the necessary and proper clause when we're interpreting, quote, the public use clause. P.S., it's really 2 words, not a clause. And when we do that, what we somehow find is it's only a public use if it is carrying out an express power in the Constitution. Now, he's on his own, and it is a very, it's not exactly clear how you get all those different constitutional principles into public use. That's his decision. So I'm going to, since I've talked a long time, not editorialize too much, except to say I think that, to me, the takeaway message is it's not a revolution, this case. It's really affirming long-standing authorities that governments have had. It doesn't mean that governments will always exercise it wisely, and there's a lot of discussion about that by the court. And the real attention to be paid is to be paid, how can we get governments now to exercise this authority carefully? The majority does say, of course, state and local governments can have more narrow laws. And in today's New York Times, although they don't exactly perfectly characterize what the holding is, they have a discussion of some of the federal, state, and local laws that are coming into play. And my favorite is in Texas, where they're adopting a law that says one private person can't take it for the use of what they call another private person, except the Texas football stadium.
That's terrific summary. Caitlin?
Let me take a few minutes to tell you about the second case, which is Lingle versus Chevron. Lingle is a case that clarifies the test for when a regulatory taking has occurred. And the court's holding, as a couple of people have remarked, is sort of reminiscent of the way that Roseanne used to close Weekend Update on Saturday Night Live. She would say, "Never mind," after having screwed up whatever the relevant report of the day was. This case has its roots in a decision by the Supreme Court in 1980 called Akins. In Akins, the court said that there is a taking if a statute doesn't substantially advance the government's goals. That language crept into the case law of the Supreme Court and the lower courts, which took the phrase and in a number of instances in the lower courts used it as an independent basis for determining whether a regulatory taking had occurred, separate from the factors that are usually applied in the Penn Central test that Lois mentioned. And so this meant that the courts could essentially conduct a means-ends inquiry into whether or not a statute was effective, and if they concluded that it wasn't, they could strike it down. That's exactly what happened here. In this case, the state of Hawaii passed a statute that imposed some rent regulation on dealerships for gasoline service stations. Apparently in Hawaii, the market for gasoline at the wholesale level is very highly concentrated, which leads to high consumer prices. The reason for the high prices in the rest of the country must be something else, I guess. What Hawaii did was to cap the rent that the oil companies could charge independent dealers who were leasing a service station from them at a certain percentage of their wholesale and gross sales. Chevron, which is one of the oil companies that has a substantial presence in Hawaii, sued the state of Hawaii, arguing that this statute constituted a takings. What the district court did was to apply Akins. It conducted a fact trial that was a lot like what you might expect a legislative proceeding to be, where the legislature was deciding whether to adopt a law like this, complete with experts that testified to the impact that this law might have on gasoline prices. The court asked whether or not the statute substantially advanced this goal of lowering gasoline prices and said that it found the state's arguments, and I'm quoting, just not persuasive. So it declared that the statute was a taking, and the Ninth Circuit agreed. At this point, the court granted cert, presumably to consider whether this inquiry of whether the statute substantially advances the government's interests really had a proper role in regulatory takings analysis. And at this point, the state of Hawaii also persuaded Seth Waxman and his firm to join in representing them. At argument, Justice Scalia said to the state, look, what you're really asking us to do here is to eat crow, aren't you? You're asking us to acknowledge that this means-ends test that has been kicking around in our case law for the last 25 years was all wrong in the first place. I think that the Attorney General of Hawaii found a relatively diplomatic answer to that question, but the answer was essentially yes. What Hawaii was asking for was for the court to clarify that this inquiry had no role in determining if a regulatory takings had occurred, or alternatively, that if it was going to insist on conducting that kind of search, that it do so with extreme deference to the state legislature. Justice O'Connor's opening line in the unanimous opinion I found to be really wonderful. She says, on occasion, a would-be doctrinal rule or test finds its way into our case law through simple repetition of a phrase, however fortuitously coined. Well, as you can imagine from that, the test is gone. The court clarified that the means-ends inquiry that had flowed from the substantially advances language in Aikens really had its origins in the Due Process Clause, that it was about whether or not a law was effective or made any sense, and that really didn't have much to do with the crux of whether a regulatory taking had occurred. Penn Central, which is the case that sets forth that test, really has to do with the magnitude and the character of the burden as experienced by the entity subject to whatever the regulation is. Whether or not the taking is an effective one, whether the regulation is an effective one or not, probably doesn't matter much to the individual who is saddled with the burden. So the court cast it aside. The court also outlined the categories of takings that it thought still remained, and this is really just a confirmation of the case law as it stood at the time the case was decided. First of all, it said there are per se takings, either a permanent physical invasion or the deprivation of all economic benefit of the sort that you saw in Lucas. Second, there are regulatory takings where when you apply the Penn Central test, you decide that the magnitude and the character of the burden is so severe that a taking has occurred. And then it also referred to cases like Nolan and Dolan where you have some sort of an exaction. In other words, you have a condition that is imposed in order to obtain a permit, which is very much akin to a physical appropriation itself. So it really set up the doctrinal boxes that it expects to be used going forward and provided some additional clarification in that manner. So the case is obviously important from a doctrinal perspective. I also think it's really important from the perspective of governments, and here I guess I should recite the disclaimer that my opinions are mine and not necessarily those of my employer, but if you are representing a state or local government, or I would presume the federal government as well, this means-ends inquiry was really a dangerous one because what it allowed the federal courts to do is to scrutinize with a fair amount of intensity, and the district court's decision in Lingle really makes clear what a problem this is, whether or not the legislation was a good idea or a bad idea. And not only is that something that I think has largely been discredited since the Lochner days, but it's something that imposes a tremendous burden if you're in the business of defending these kinds of statutes. That sort of litigation is really expensive, it's expert intensive, and also it allows courts to really second-guess the legislature's determination about the efficacy of a particular solution that it's adopted. So from our point of view, I think this decision was unexpected. It was certainly the result that doctrinally made the most sense, but it also was really important because it closes down this avenue for litigants in Chevron shoes to present challenges and sometimes to have statutes set aside as a result.
That's terrific. Seth, San Remo?
I'll say a few words about San Remo, which, as Bill suggested, ended up being much more a decision about civil procedure and full faith and credit than takings per se. Let me just say at the outset for everybody who's standing in the back, there are about 10 seats in the front. I mean, maybe you want to preserve your options and, stay close to the exit so you can leave relatively unobtrusively. But those of us up here will be watching. So if you really thought there wasn't a place to sit, there are places in the front. I think probably the best lead-in for me to San Remo is just to make a few quick observations to embellish Caitlin's excellent and concise discussion of Lingle. Because the cases contrast so nicely, they're both Ninth Circuit cases. It was a great pleasure for me to be involved in out of the two cases, to have at least one in which I was able to forcefully argue to the Supreme Court, not that the Ninth Circuit should be overruled, but that the Ninth Circuit clearly got it right and should be affirmed, which was San Remo. There are also the Ninth Circuit's opinions in the two cases actually on the substantially advances test are totally inconsistent and completely incoherent, but luckily in San Remo, the Supreme Court didn't grant cert on the substantive takings question, so that embarrassing little fact didn't have to be publicly aired. Lingle, unlike San Remo, was a test case. It was a classic speaking now as a litigator, not as a scholar, which I don't pretend to be. The former I do pretend to be. But the Supreme Court had been trying for many, many years to address the question that it finally decided in Lingle. That is there a substantially advances test under the Fifth Amendment just compensation clause? I mean, the court said so in Agins versus Tiburon, as Caitlin suggested. But in Agins versus Tiburon, that statement was not necessary to the court's decision, and the two cases that the Supreme Court cited and discussed to support the notion that unless the legislation substantially advances a permissible goal, it's a taking, were in fact due process cases, pretty well known. Necto versus City of Cambridge and Village of Euclid versus Ambler Realty were both cases decided under the due process clause, and yet in the context of a Fifth Amendment takings case, the Supreme Court started all this mischief in Agins versus Tiburon, and it knew that it had created mischief and had granted cert in two earlier cases to address this question, most recently Del Monte Dunes, which came up while I was, Bill and I actually were in the Justice Department, but there were always procedural problems with getting to the question, a reason why the court couldn't address the merits. And people interested in this doctrinal area had been looking for a long time for the right case to give the court the opportunity to reject this, I think as Caitlin has suggested, really pernicious notion that it was sensible to have a regime in which a constitutional challenge would be brought to economic legislation, economic regulation, and a single district judge would say, well, I'll hear an expert from Chevron and I'll hear an expert from for the state of Hawaii, and I'll decide which one is more credible, and if it's Chevron's expert, I'll declare this to be unconstitutional. I guess I should note in passing that I think I see behind the glare of the lights Judge Fletcher, who, if I have this right, Willie, dissented, importantly, not once but twice in Lingle versus Chevron, and so let the credit fall where it may. There's a profile in courage in our midst. The interesting thing that the court didn't do in Lingle and also didn't do in San Remo, which I really am about to get to, is to consider whether or not either the state legislation in Lingle or the city ordinance in San Francisco could be characterized as an exaction, which is a term that, sends chills down the spines of the non-property rights side of these issues, because in cases called Nolan and Dolan, accommodatingly, we have Tweedledum and Tweedledee. Nolan and Dolan involved instances in which local governments required pretty onerous and pretty odd easements as a consequence of granting a zoning permit with respect to a landowner's use of a particular property. And in Nolan and Dolan, it seems pretty clear that the court has established that if a government wants to exact an easement from real property as a condition of letting a property owner do what she or he wants with the property, unless the easement is, quote, substantially advances the goal for which the city could have denied the permit entirely, the government has to pay. And an argument was made by Chevron in Lingle, and certainly was made by the San Remo Hotel in San Remo, that these weren't just regulatory takings, these were exactions, and if they're exactions, the substantially advances test still applies. The Supreme Court rejected with the back of its hand that notion. In fact, it may not even have mentioned it in Lingle, and didn't address the question in San Remo, although the California Supreme Court pretty convincingly rejected it there. So San Remo was a case about not a state law, but a city ordinance, similar to the New London instance, except that in New London there was a ruling and a permit granted with respect to a particular development, and in San Remo there was a San Francisco ordinance that basically provided that if you are an owner of what's called a residential hotel and you want to convert some or all of the rooms of the residential hotel to tourist use, you have to provide to the city, you have to bring online an equivalent number of units for residential use, or pay into a special city residential use fund 80% of the cost of building and bringing online a replacement unit. And this was an ordinance which had been challenged many times on takings grounds. There was a case, I've forgotten the name of it, which actually went to the Supreme Court a few years before San Remo got there, and cert was denied, but there was a dissent from denial, I think by Justice Scalia, for a few justices, which basically said, regrettably, the constitutionality of this ordinance cannot be addressed in this case because, I don't know, it doesn't present the question, or this is a poor vehicle, but, and I'm paraphrasing here somewhat facetiously, Justice Scalia writes, we may only live and pray for the day in which this ordinance actually is presented before our court in a case that we really can appropriately adjudicate. And it was, in fact, presented in San Remo. The ordinance, the case as it was decided by the Supreme Court was decided entirely on sort of civil procedure, full faith and credit grounds. There is a concurring opinion written by the chief for 4 justices that addresses an important takings question, that so-called Williamson County question that I'll explain in a minute, because I think for purposes of this discussion it's what we ought to be talking about. But I've told people that in my long career I have never actually encountered a case that was as procedurally bollocksed up, factually incoherent, and doctrinally complex as this case. I mean, a scholar friend of mine actually said to me after looking at this that you could teach the entire 2nd and 3rd year of law school based on San Remo. And, you know, that was actually sort of comforting to me, because I actually thought that, well, maybe I'm sort of losing it here. The petitioner in the case, the owners of the San Remo Hotel, wrote their blue brief in the case. Their topside brief was only 21 pages long, and it had, like, huge margins. And, you know, I found it challenging to write a fair statement of facts in fewer than 50 pages because it was so complicated. But I'm leaving all of that aside. Let me just explain what the Supreme Court decided. The question that the court actually wrestled with was, to what extent is it true that the plaintiffs in the case, the owners of the hotel, were improperly denied the opportunity to litigate their federal constitutional takings claims in federal court? What happened was, when the city decided in a series of proceedings that they had to pay several $1 million in order to convert their residential hotel to tourist use, they filed suit in state court challenging the zoning decisions that the city had made and nothing else. They then told the state court that it shouldn't actually adjudicate any of those issues, but it should wait because they were about to run to federal court in the Northern District of California and challenge the constitutionality of the whole regime, which they did. They filed a lawsuit in the Northern District challenging on state and federal constitutional grounds as applied and facially the ordinance, the hotel conversion ordinance. They did so, they split their claims because this federal judge to whom the case was assigned had just written an opinion in which he opined that the ordinance was manifestly unconstitutional, and the judge promptly entered a temporary restraining order and a preliminary injunction, which the city appealed to the Ninth Circuit. The Ninth Circuit looked at this and said, there shouldn't be a preliminary. I mean, it didn't. The appeal to the Ninth Circuit, and while it was pending before the Ninth Circuit, the good judge met his maker, and the case was assigned to another judge, and the city then withdrew its appeal and litigated the permanent injunction and the permanent relief, and the district judge said, a very well-respected district judge said, this case is untimely, and in any event, it's barred by a doctrine called Williamson County, which I'm about to discuss, and therefore this should be it's not ripe and it should be dismissed. Goes to the Ninth Circuit, and in the Ninth Circuit, the San Remo, which had won the preliminary injunction in the district court, tells the Ninth Circuit, and which had run to federal court to begin with, that it should invoke the Pullman abstention doctrine and stay its hand so that the claims that they had brought in federal court could be adjudicated in state court. The Ninth Circuit deemed this, perhaps the ultimate act of chutzpah, but nonetheless felt that the facial claims should be granted. This Pullman abstention should be granted, and Williamson County abstention should be granted for the other claims. Now, Pullman abstention, as you know, is if you raise a federal constitutional question in federal court, and it turns out that the resolution of that question depends upon the construction of a state law that the state Supreme Court hasn't construed, the federal court can abstain while the parties go back to the state court and get an answer to the state law question, which, depending on how it's answered, may or may not obviate the need for federal court adjudication at all. Williamson County, which is the key here, is a case in which the Supreme Court, in a Justice Brennan decision, 20 or 30 years ago, for a substantial majority of the court, said that if you're going to bring a federal constitutional claim under the Takings Clause to federal court, you need to do two things first. First of all, you need to make sure that you have a really final ruling of the local government, the zoning officials. You have to, if there are procedures that you can invoke before the zoning officials in which you can get a variance, for example, from an ordinary rule, you need to do that. We're not going to adjudicate these cases until you have a real final decision from local government. And moreover, because this is the just compensation clause, there is no federal constitutional violation that is established or therefore can be pleaded until the state has denied compensation for what otherwise would be a taking. And therefore, after you get a final zoning decision, you need to avail yourself of whatever procedures the state has, and the Supreme Court in a subsequent case decided that states must have such procedures, to get compensation for it. And only if you are denied fair compensation for a final agency action that takes your property can you come to federal court. So what happened in San Remo is the Ninth Circuit agreed that they could go back to state court. When they went back to state court to revive their state law zoning challenge, they didn't limit their claims to that. They amended their claims in state court and alleged a facial and as-applied challenge under the state constitution, California's takings clause. They told the state courts that they didn't want any adjudication of their federal constitutional rights, only their state constitutional rights. And there then ensued years of terminally convoluted litigation in the state courts, resulting in I believe that there was a fractured decision in the California Supreme Court. I think only Janice Rogers Brown actually dissented. But the majority basically said, there's no takings violation here. Let's go through our state constitution. We construe our state constitutional provision in pari materia with the federal takings clause. And there is no need here for heightened, substantially advances scrutiny of this ordinance because it's not an exaction. And it's not like Nolan and Dolan, and there wouldn't be heightened scrutiny under federal law, therefore there isn't under state law. This is plainly rational. It's plainly constitutional. Janice Rogers Brown writes a dissent which starts very close to the following. Private property, long an endangered species in the state of California, has become entirely extinct in the city of San Francisco, which I think must have been sort of a surprising revelation to the many, certainly recently very wealthy landowners who happen to own homes in San Francisco. So they lost in the California Supreme Court, whereupon instead of filing for cert in the Supreme Court of the United States, they went to federal court and said, okay, we did our little state court thing that either we asked you to make us do or you told us we had to do. And they said, we now want an adjudication of our federal constitutional claims against this ordinance as applied and on its face. And the state judge said, I don't think so. This is still barred by the statute of limitations, and now you are precluded under the full faith and credit statute because the state court has already adjudicated all of the issues that would have had to be decided under the federal constitutional claim, and you get one bite at the apple. You chose to bite the state apple, the state court apple, and you're finished. And the Ninth Circuit affirmed, and the San Remo Hotel filed a cert petition that raised two questions. One, whether it could possibly be consistent with ordered liberty for a landowner that alleges that his property was taken without just compensation under the Fifth Amendment could be denied ever having a federal court look at that federal constitutional claim. And two, whether it is in fact true that the substantially advances test doesn't apply to ordinances that exact large fees in exchange for development. The Supreme Court denied cert on the second question, and so the question presented really was, in a context in which in seeking just compensation under the requirement from state courts, under the requirement of Williamson County, the state court adjudicates issues that are dispositive of what will later be a federal constitutional claim. The party bringing a federal constitutional claim in federal court can be precluded from relitigating those issues that were decided against it in state court. And the Supreme Court decided the question in a very straightforward fashion by saying, the answer is yes. There is a full faith and credit clause in the Constitution. And to implement that clause and to apply it to federal courts, the very first Congress of the United States enacted the full faith and credit statute, which has always been construed and understood to mean that principles of res judicata and collateral estoppel apply to litigation in federal court with respect to issues or claims that have already been adjudicated in state court. And we have applied that in the context of 1983 litigation, in the context of habeas litigation, and we are certainly not going to make an exception for it here. There was no dissent in the case from that holding. There were 4 justices in a concurring opinion authored by the Chief that said, well, there's no question, none of the parties here have argued that Williamson County, the Williamson County requirement that you seek compensation first in state court, be re-examined. But we probably ought to re-examine it. The Chief says, I joined the majority in Williamson County, but, perhaps I didn't really think this all the way through, and this seems sort of odd that since we require the seeking of just compensation in state courts, we're going to apply the Full Faith and Credit Act and full faith and credit principles to bar litigation in federal court. Only Congress can change the mandate of full faith and credit, but we can re-examine whether it makes sense to require landowners to present their compensation claims first to state court. And maybe we'll talk about this some more later. It's a really, really interesting question as to which I'm not sure that the left and the right, insofar as you can denominate left and right in takings clause cases, have figured out which court they would prefer to be in. In the habeas area, where I've done a lot of litigation for more decades than I care to acknowledge, prisoners are always trying to get into federal court and get a federal court, a full and fair adjudication of their federal constitutional claims, however many times they're required to exhaust those claims in state court. In the takings area, and therefore it was a little bit odd for me to find myself in the Supreme Court saying, well, these people had their shot in state court, and it's true that the state court didn't really adjudicate their federal constitutional claims. They didn't want the state court to, and it didn't, but, it adjudicated claims that, were sort of like those federal constitutional claims, and that's good enough for the Constitution and Congress. So it's a very interesting question that certainly is going to rear its head again.
Well, that's terrific. That's a great summary. I think I now understand the case. So, and just before we get into kind of the substance, were you surprised that the court took 3 takings cases?
Well, it's more than they usually take. Having been sort of involved in all 3 of them, I have to say that I was delighted. But I don't think that they were. I think that Lingle, I quite agree that Kelo is the case of enduring significance and probably what we ought to spend the rest of our time talking about. But Lingle and Chevron, Lingle and San Remo were taken in order to answer very particular lingering questions about the procedure of adjudicating, lingering questions at the periphery of the Just Compensation Clause jurisprudence. The court had been looking for years for a vehicle to decide the question that was decided in Lingle. And the seeming anomaly of applying Williamson County to the full faith and credit regime posed a very discrete, very distinct doctrinal question that the Supreme Court felt that it had to resolve. But now that it's resolved that question, I think it's done and it's decided. And so I think what happened by taking all 3 of these cases, I don't think you see sort of concerted action by a group of 4 justices saying, okay, let's go in and clear up. We did bankruptcy last term, let's do the takings jurisprudence this term. I think there is a lot to be cleared up in the takings area. I quite agree with Lois that the Tahoe Regional Planning Agency case was the court's first important step in doing that, and these other two cases other than Kelo reflect that trend, I think.
That's interesting.
I would also add they've taken a lot of environmental cases over the past several years, and if you see takings partly as environmental, although these particular cases might not have been so heavily that, it's in keeping with that trend.
I mean, I'd be most interested to hear what Joe and Steve have to say about these three cases and whether, because I may be looking at these purely from the sort of, retail level litigation perspective.
Okay, why don't we start with Joe talking about where we are, and then I'd like to hear from Steve then.
Well, let me start with respectfully disagreeing with Seth. I think that what is of enduring significance, what will turn out to be of enduring significance from this term's cases, is the dictum in Lingle. That is to say, it is what Lingle and Tahoe Sierra together tell us about where substantive takings law is likely to go. That's what's most important. I certainly agree that it's not the getting rid of the Agins test that is critical. But let me say a couple of things. Let me start with property as an extinct species and Janice Brown. I just want to say on behalf, as a homeowner in San Francisco, on behalf of the people of California, we want to thank President Bush for moving her to the District of Columbia. That's not exactly a takings view, but the second thing is I want to say something about the Agins test just preliminarily, particularly for those people who do not intensely follow these cases. It may seem odd at first that here is this formulation, substantially advanced legitimate state interest, that the court has repeated over and over, which actually doesn't come originally from the Agins case in 1980, but comes even earlier from the Penn Central case in 1978 and going back to the Nectow case even earlier. The reason for this, the reason it happened was that back then, in 1980, it was before the court had decided the first English case, the so-called temporary takings doctrine. And at that, or up until that time, it didn't really make any difference whether a regulatory ordinance was a taking or whether it was invalid as a violation of due process. Because in practice, what happened in both instances was that the law was simply not enforced. It was repealed or put aside, and the effect was the same. So if you look at old cases, you'll see that it's very common for them to talk about takings and due process sort of in the same phraseology, and even saying, as even the court did in Penn Central, that if it doesn't substantially advance, it's a taking. It's only when was it 1985, I think, that the court decided first English and said if there was a taking, then you would get compensation for the period that this uncompensated valid regulation was in effect, that it became significant. So Agins was a kind of useless appendage that just hung on, and the court finally got there, which is all to the good, because it was potentially very mischievous if it was to be misunderstood. Let me take what little time I have at this point to just say something about where I think we are and where I think we're going. I think many more casual observers of takings doctrine would say the following to you. If you look at the court's decision in the Tahoe Sierra case, which was the moratorium case, and you look at the Lingle case in terms of what it says more generally, its dictum about takings doctrine, you get the impression that we're sort of back to Penn Central. That was Justice Brennan's opinion in 1978. It connoted where the court had been for many years, which was in a highly deferential status toward regulatory actions that diminished the value of property, and there were very, very few cases indeed in which a takings was found. If you read Stephen Engel's treatise, you'll see that he says in his new edition, you ought not to think that we're back to that kind of, I think I'm quoting you correctly, that we're not back to that level of deference or that attitude of deference. I completely agree with him. I think one needs to be very cautious because while we have the current court saying that the basic law for regulatory takings, with these couple of exceptions of physical invasions and 100% losses, that the basic law is Penn Central. I think the important thing to keep in mind is this isn't the same court interpreting, quote, Penn Central doctrine as we had in 1978. It both is and is going to become a more conservative, in the sense of more sympathetic to property rights court than the court was in 1978. And just as a little footnote to that, interestingly, if you go back and read Penn Central, you'll see that one of the three dissenters was Justice Stevens. Interesting point. And also, if you look at Justice O'Connor's opinion in the Lingle case, she adds a couple of curlicues to Penn Central doctrine. And one of them, I think, is particularly important. The Penn Central doctrine says there are essentially three factors. You look at the diminution and, in particular, the effect that it's had on distinct investment-backed expectations. And you also look at the nature of the government's action, which thought to refer to the invasion-type cases. The court cites the Cosby case, which was the airport flyover case. But one of the things that Justice O'Connor emphasized in the Lingle case was what was called singling out, and the reference to the Armstrong case. And the Armstrong case, which is often cited, is cited for the proposition that the essence of what underlies the takings clause are concepts of fairness and justice. And you will see that she says that in her dissent in Kelo, citing the Armstrong case. So here's my prediction. These more conservative justices, now confronted with the Penn Central doctrine, may very well say, you know, it's really this Armstrong notion, this notion of fairness and justice that's at the heart of takings, and that one of the most serious problems, perhaps central to identifying these takings when you have significant economic impact, though far from the 100% of Lucas, is whether in some sense this party has been singled out to bear a burden that in fairness and justice should really be borne by the community at large. And if that's the way they look at the cases, you could find them being far more ready to find takings in a lot of regulatory cases than certainly the court was at the time of Penn Central. Because where they are, I think what's happened is they've essentially given up on Justice Scalia's effort to try to find a sort of doctrinal, conceptual, rule-based way of looking at these cases. And I recognize you have to sort of look at the cases individually, and so, fairness and justice and singling out has a lot of appeal for, just as an example, thinking of this as if I was advising the property rights people, I'd say, if you want a singling out fairness and justice case, how about one of these Endangered Species Act cases where here's the reality that you explain to the court. X species, which is now terribly endangered, used to be all over the place. Why is it now endangered? Well, because all these people who own property on the habitat, former habitat of the species, have built houses and built apartments and built shopping centers. And now, as Justice Rehnquist said in Penn Central, the one person who has left, who has done good by leaving some space for this endangered species, just like the one person who built a nice building that nobody wants to tear down, is now being penalized for their good works. And, it isn't this person's fault that the species is endangered. It's all these other people who have developed in the habitat. And it's really quite unfair to impose the burden on this one person. And that's what makes this case, this Endangered Species Act case, different from the ordinary regulatory takings cases, because usually either it's somebody's fault, you're creating a problem like a nuisance, or there's some conflict in which you're in the way, as in the famous Miller against Shoney case, where you had the conflict between two different agricultural products that couldn't coexist, or even the old railroad overpass cases, the Erie Railroad case of Justice Holmes, where you got a highway and a railroad, somebody's got to give way. So they pass an ordinance and say the railroad has to build an overpass. At least it may not be your fault in the sense that you did something wrong, but it's at least you created the problem. But in the endangered species case, and I'm just using this as an example, sort of pretending that I'm making this argument, it isn't really their fault at all. It isn't really they who have created the problems. They just get singled out for something that really ought to be borne by the community as a whole under the Armstrong principle in fairness and justice. Now, I suggest to you that that's the kind of claims you're likely to see. And that's the gloss that I suspect advocates for property owners in takings cases are going to try to put on Penn Central. How the court will respond to this, I mean, how the current and the new court will respond to this, I don't know. But I do want to put up that warning flag, and at least put that out for discussion by my colleagues.
That's terrific. And so let me now, that's a move to Steve, and let me frame two questions for you, Stephen. One actually builds on what Joe was just talking about. I mean, it's always struck me, the way in which takings dialogue is set up. There's the right's approach, which is typically the categorical rules. And the left's approach has always been Penn Central. But, I mean, I've always thought that Penn Central was really a bad case for the left. It really comes out of Frank Michelman's approach, which I think is completely of a piece with his, the kind of the judicial activism that he was very strongly embracing at the same time. It's a very open-ended test that allows a conservative court to strike down a lot of stuff, even if the court in the Supreme Court in the late 1970s wasn't using it in that way. And it also, because it's so open-ended and amorphous, seems to me to have a substantial chilling effect on planners. In other words, they don't want litigation, and they're afraid of what a court will do. And so, because Penn Central is so open-ended, they, from my view, don't regulate in ways that they should. So one question I'd like you to talk about is kind of your views on Penn Central. And the other is your views on Kelo, which is really, I mean, that's the hot issue of today. Do you think it was rightly decided? What do you think the consequences of it are?
Thank you. First, on Penn Central, I think that the point that Bill raises is absolutely correct. and it's also been raised often by John Echeverria, I think, very effectively. Frankly, one of the things that bemuses me about the Lingle case is Lingle says that we ought not to use substantive due process in dealing with the takings clause, but the court's Penn Central analysis is substantive due process. It talks about fairness, it talks about impact, it talks about expectations, whatever that may mean. It talks about everything except discrete units of property rights. And since it's constantly going back to this refrain of ends, means, and fairness, it's simply, to me, a substantive due process test of a different genre. And I think that both Joe Sachs and Bill are absolutely correct in thinking that certainly if appeal is to fairness, that individual property owners often have very just grievances in this, and I do expect this to be used more often. On the Kelo case, I think the best thing that could be said for Kelo is that it's arguably not inconsistent with the court's prior cases, but that it's far more sweeping than the court's prior cases. Kelo, in effect, strips the public use clause of any constitutional significance. It says that condemnation for retransfer for private redevelopment, if intended to satisfy some kind of public purpose, and if it's not done arbitrarily and it's not done with malice, then it's okay. There's no inkling in the case of the importance of individuals having their own homes, their own businesses, that you see from the time of the Glorious Revolution in England, from William Pitt through John Adams and A Man's Home is His Castle, through the kind of popular outcry that's going on this very day, and that's in the newspapers, and that only surprises, I think, academics and others who see the theory but don't necessarily haven't dealt with people who have the real concern of having their property taken away. I think Lois Schiffer was correct in saying that Justice O'Connor has changed her tune. I would say in midstream, but I guess I have to say at end game. Justice O'Connor took a very pragmatic view of things, not rigorous in logic, but pragmatic, and thought that dealing with the remnants of feudalism in Midkiff and dealing with redevelopment of slums in Berman, that's all good, and so let's allow that. The problem is that there's no way of cabining this, as Justice O'Connor now sees. And if I may bring up a case that Justice Stevens mentioned in his majority opinion, 99-cent stores versus City of Lancaster, it is possible, and indeed it was done, that a large redeveloper, Costco, went to the city and said, we're big players in your urban redevelopment project. Unless you let us have unless you let us have our competitors' land across the street, we are leaving. And so the city officials said, okay, it's yours. Justice Stevens says we can deal with those abuses when we come to them. But the fact of the matter is this is all done at a very low level of visibility. It's all done largely through winks and nods. And it's very hard to come up with the kind of smoking gun that Justice Stevens emphasized was not present in the Kelo case, where there was no explicit deal between the Pfizer pharmaceutical company building its research headquarters and what the City of New London and the state of Connecticut would do with the tract it was condemning next door. Well, but that misses the whole point. You don't need a smoking gun. If the City of New London and the state of Connecticut are going to lure in people for future redevelopment, that is largely dependent on word getting out that Pfizer was pleased by what happened in its situation. There's going to be an hydraulic pressure to please interests that come in, and of course the people who pay the penalty for that are going to be the individuals whose land is condemned, and lest we forget, full compensation as it's defined, just compensation as it's defined in the Constitution, never is full compensation. So that's the legal side of it. From a policy side of it, I think progressives ought to be very troubled by this case. It's no accident that Maxine Waters has joined with Tom DeLay in fighting this, and it's also no accident that the NAACP took the side of Mrs. Kelo in the litigation. The fact is, condemnation for redevelopment almost inevitably favors the strong over the weak and the well-connected over the voiceless. Those of us who are old enough to recall the Great Society redevelopment programs saw that what was termed urban renewal was called by others Negro removal, for taking inner city neighborhoods, clearing them out, putting up upscale projects on them. And in fact, it's not even very clear that this kind of scheme and comprehensive redevelopment in the long run helps cities. The Washington Post a few years ago had a very long story about what happened in the Southwest Washington neighborhood that was the site of Berman versus Parker, and looking back at it in retrospect, neighborhood residents are very ambivalent about whether the scheme actually helped the city and helped their lives or not. And finally, one of the problems with this kind of scheme is that it helps shove under the carpet more deeply structural problems in state and local governance. For instance, it's true, as Lois said, that New London is a depressed city, but it's a poor city in a rich state. Why isn't the state of Connecticut doing more to help New London? Well, the state did very actively get involved in the kind of urban redevelopment scheme that was condemning the land of Mrs. Kelo, a registered nurse, and her neighbors in a basically a working or middle class neighborhood. The pressure for getting increased tax revenues was responsible for the 99-cent stores only case in California, and also responsible for the denial of a permit for the Cottonwood Christian Church to build a church building on a main street because the town wanted a big box store, yes, Costco, to be there instead to generate revenues. So what's happening essentially is that we have a mechanism where localities are being encouraged by states to seek large, well-funded companies to come in to do renewal, and rather than raise tax monies in a more direct or more equitable way, the burden is falling on local residents. I think that this should give us all pause about whether the public use clause really should be reinstated as having constitutional relevance.